Good afternoon, everyone, and again, welcome to our third webinar of 2024 for the Strong Foundations Professional Development for Geotechnical Engineers Non-Technical Webinar Series by the CGS YP Committee. This is the seventh webinar since we started the series last year. My name is Leonardo Paranhos. I am a graduate student in Geotechnical Engineering at Western University based in London. Thank you for joining us today. Some housekeeping items. Please keep your questions in the Q&A field. We have recently switched to the Teams platform, so please be patient with us while we learn the platform. If we have time at the end, I will read out questions to our speaker. And lastly, please feel free to join our LinkedIn group. It's named CGS Young Professionals Committee to keep up to date with our initiatives. With that, it's my pleasure to introduce our speaker for this webinar. Kathryn Ekman is a contracts and risk specialist with 18 years of experience in geological engineering. She holds a degree from UBC and has worked extensively across British Columbia. Currently, Kathryn is a contract specialist at McElhanney and a board member of ACEC BC. Her expertise spans contract negotiation, project management, and quality management. She's also passionate about social justice and volunteer work, making significant contributions to both her profession and community. Please join me in welcoming Kathryn Ekman.
Hello, thank you very much for that wonderful introduction. I appreciate it. And welcome everyone. Thank you for devoting your time today to this topic that I warned right in the title can be boring. However, I will do my best to bring you some useful information today. My understanding is the audience is most likely primarily in Western Canada and also most likely primarily people in the consulting side of engineering. So given where I have spent my career, which is in consulting engineering, this presentation certainly has that perspective. However, I have made my best effort to make sure this is applicable and useful to everyone. So if you are on the owner side, client side, perhaps you work in government, there may be moments where you want to imagine a different type of relationship than what I'm describing, but this perspective should still be of value for you. I'm sure you'll be able to think about how it would apply. And also because many of us move around and try different things throughout our careers, I certainly have. This may be something that some of it may become more relevant to you later on, depending on what you do throughout your career. So today we're going to cover 5 topics. We're going to start with laying a bit of groundwork, so to speak, about professional liability. And then we'll get into some common misconceptions around risk management before we get into my advice for managing professional risk. We'll talk a little bit about contracts, and then I want to leave you with some suggestions on what you can do specifically as young professionals in the field. Not in the field as in out in the field. I realize a lot of my language has some multiple connotations to it, but meaning in geotechnical engineering. So to start off with professional liability, I want to get some, I suppose, just some clear definitions about what we're speaking about. For some of you, this might be content you've recently learned at school, or if you have done your P.Eng, you would have done some law and ethics learning. So it may be a bit of refresher for you, or perhaps a different take on it. But in any case, I just want to make sure we all have the same use of language here, and that will include talking about how negligence is defined. Very exciting. Disclaimer up front, and this wouldn't be a presentation with a legal angle on it if I wasn't making disclaimers. But this presentation is not as applicable in some senses for Quebec because that's the only jurisdiction in Canada with a civil code. When I'm talking about interpretation of law a little bit here to start with, I don't have that expertise in Quebec in the civil code, so this will be more applicable in the other regions of Canada. And while I'm at it, none of this is meant to be specific legal advice, and I'm not a lawyer. So I am certainly an engineer who was very interested in this part of the work. But if you have any specific concerns or legal aspects you want input on, then I strongly advise seeking someone knowledgeable to ask about that. It could be through your employer or otherwise. All right, now that I have made all of those disclaimers for my own sake, I'd like to talk about a few things regarding professional liability. So, liability essentially just means legal responsibility or wrongdoing, which could be an act or omission, or it could be a failure to act. For simplicity, I'm mostly going to talk about actions. But essentially, as a professional engineer, you can attract liability intentionally or unintentionally. So if you do something intentionally wrong and it goes against the criminal code, then of course that's a criminal act. And that goes through the whole criminal um, procedure, right? So I'm sure we're familiar with what that means and how that could proceed. If your action was not criminal, then you could still be liable under civil law. So that means someone could sue you for damages, essentially. So those are our kind of two branches that we want to think about from the start. We've got criminal and then we've got civil. If your action was unintentional, this is where that concept of negligence comes in, and we'll dive a little bit deeper into that. So, professionals are liable for negligence in their practice and can be held accountable under civil law, meaning someone could sue you, and through professional governance as well. Um, Little side note for completeness, negligence as a professional engineer can be criminal if it shows what they call wanton or reckless disregard for the lives or safety of others. So if something is so dangerous to others, then you could have a case of criminal negligence, but that's pretty extreme. I'm sure none of you will ever be caught up in such a thing. So what I'm talking about today is non-criminal, regular negligence. And there are two key ways this could come up. The first is breaching the law or ethics. So in BC, which is where I've practiced, so I'll take that as the example, we have the Professional Governance Act. And that's essentially a framework that governs the practice of professionals like engineers and geoscientists. So if I don't follow the requirements that are set out for me as an engineer under the Act, if I don't follow my code of ethics, that is a breach of the law. And if now I'm going to stop using myself because this feels too sensitive. If someone breaches those requirements, they could be investigated and disciplined by the professional association. So in BC, that would be Engineers and Geoscientists BC. The second key way that this might come up is typically through a breach of contract. So two parties can agree whatever terms they want in a contract. And then if one party breaches the terms, so for example, if the contract requires you to keep everything confidential and you don't, then there's contractual liability there, and the other party can sue for breach of contract. So I want to dig a little deeper into exactly what we are talking about when we talk about negligence. I know that you're riveted by this, but essentially, just again, to have that clarity on what we mean. And also, I think it's very useful as engineers to know what these things really mean because they come up and you hear the word used quite a bit. So it's worth understanding what it means besides just an unintentional wrong. And there are four elements that are required for negligence to be proven under the law. Sometimes people combine two of these, and so they might say there are three elements, but at the end of the day, it's these four things. First, you have to have a duty of care to the plaintiff. So if you're a consultant, this is typically your client, but it applies to anyone that you would have a duty of care to. That could include the public, it could include third parties. And you must have breached that duty of care. And then that breach has to be the cause of the harm or the damages. So we say the harm or damages must be reasonably foreseeable because of whatever that breach is. And then the plaintiff, whoever it was, must have suffered actual harm or damages. It can't be a what if scenario, it has to be a real situation. So a perfect example of this happening would be if you're practicing as an engineer, you're working as a consultant to a client, but if that's not you, then think of a scenario where you are performing your services for somebody or you have a duty for them. You make a mistake. So it could just be an error in design. And then let's say there's construction happening and someone is relying on that design to do something. Maybe they're placing fill or something. Your mistake has led to errors or mistakes then in that construction. And in order to fix it, there will be costs, which we would call damages, associated with maybe removing some fill or replacing it or something to mitigate that error. Those are actual damages. They're directly attributable back to that design error. This would be a kind of classic case of negligence that occurs. And it's not frequent, but it's not uncommon that these things happen. So now I want to talk about the impact of what happens when these things occur. And I've put the title here, Impacts of Claims. You'll hear the word claim, and it can be used in different ways. So someone might use it to mean insurance claims. In this case, I'm using it in general to mean when someone comes to an engineer or their company claiming damages. It could be a letter that arrives from someone's lawyer that says, um, my client had this issue. It cost them $1 million, and it's your fault. You owe us. You need to make it right. That could be a claim. So there are many negative impacts from navigating a claim or a lawsuit against you, or typically it would be your firm. The most obvious one, and the one that gets talked about probably the most, is the financial impact. So that would be having to defend or settle a claim. And this can come in the form of direct costs, so legal representation, hiring lawyers, paying out settlements or fines. But there's often a lot of additional financial cost that is difficult to even capture, that comes from the time spent by whoever is involved on this claim, trying to defend it or deal with it, instead of doing their routine regular jobs or revenue generating work. Because even if your employer has in-house legal counsel to deal with these things, when there is something that potentially needs investigating internally or to figure out what happened, a lot of people that might have been involved will spend their time digging into it. You'll need the technical experts or the people involved in the project to spend their time getting into it and trying to figure it out. And that means they're not doing their regular revenue generating work. So claims can be quite financially impactful. The next point that comes up is the reputational angle. So if a claim is public and high magnitude, or it's of a sensitive nature, or it otherwise just reflects negatively on the company, then the reputation can be eroded. And this may lead to difficulties. If you're in consulting, that may mean difficulties winning work, and other financial problems. If you have some kind of claim situation and you're not the consultant, maybe it just means damaging relationships and causing other problems. So reputational concerns are one reason that a claim might be settled rather than defended in a lawsuit. So it might make better sense to just pay out some settlement in some cases rather than maybe damage a relationship further or turn off other potential clients or partners. And then the third thing, and again, none of my lists today are exhaustive. I just want to say I'm sharing my um, top sort of tips and input and advice with you today, but there are a lot more angles you could go down and rabbit holes on these. The third thing I wanted to highlight for you, though, if there is a claim, is the personal aspect, which is less obvious and maybe not talked about that much, but very important. It is stressful. And it can be very upsetting to find that your work or your firm is under investigation or on trial. And these things can drag on. If they're complicated, it can be months or even years, which is typically highly unpleasant for the people who are involved in it. So you could probably imagine if a project you were involved with and had done calculations even for was pulled into something like this, and you had to try to figure out if you were able to defend the work. It's not a fun experience. It can make people feel all kinds of horrible ways. So the things I'm sharing with you today, I'm sharing because obviously we all want to have secure jobs and employment, and it's important for the businesses to have good finances and reputations. But also, as individual people, I would like for you to be able to avoid being in that stressful situation. Or if you are ever in a situation where there's a claim that you're helping navigate or involved your work, maybe you will have taken some things away that help you feel a little more reassured, or just at least maybe have a better sense of how this might work. All right, so that's most of the sort of like definition type content, just giving you those basics. I want to turn to some common misconceptions about managing risks related to professional liability. Because this presentation is to quite a broad audience, it's being recorded, I couldn't get into real specific cases. The things that I've learned from are confidential in different experiences, and I've observed and learned quite a bit. But what I want to do is distill for you the lessons and the things that I've seen so that hopefully you can take away from those lessons. Just unfortunately, I can't do it with, a bunch of flashy details because that would not be okay. The first misconception I want to highlight is this idea that as long as the engineering is correct, we have nothing to worry about. I hear this, I've heard it throughout my career quite a bit, this idea that if we're just perfect, if we don't make mistakes, if we make sure the calculations are correct, everything's all right. And it is a pretty major misconception in risk management. Even very experienced engineers want to focus on their technical work, of course, and then but kind of believe as long as it's flawless, there's no problem that could really come up because they can feel like, oh, well, I know I could get up in a courtroom and defend my work. I'm very confident I'm doing my work correctly. And that's great. Like being right is great. And I urge you to do your jobs properly, don't get me wrong. But it's not a protection or like a complete defense against spending time, energy, and money defending a claim, because a claim might be made whether you're right or wrong. And increasingly, we see in the industry that when something goes wrong, a claim will be made against everyone who's even maybe involved. So maybe it's a project with a construction aspect, and your firm was involved with the engineering side, and there may not be a lot of reason to think that you did anything wrong, but all the parties involved are named in the claim. So right away, your company is pulled into it. In either way, often, maybe I shouldn't say often, but at least sometimes the quickest and cheapest way to get out of a claim is to settle it, meaning paying a bit of money to avoid spending all the time, energy, and money proving you're correct. Very few people get to the point where they can stand up in a courtroom and say, allow me to defend my work and show you why it's perfect. That just doesn't happen very much. So, I've watched really seasoned engineers suffer through the claims process and then learn the unfortunate lesson, their project contract and quality management and all of that deserved a bit more of the attention that they put mainly toward their technical aspects of their work. And often the people who have to suffer through it firsthand, and maybe through no fault of their own, but they still had to go through it, then come out as fierce proponents of some of the requirements that they used to find quite annoying. And we'll touch back on that in a moment. But besides all of what I just said, we all make mistakes. So, what happens if you aren't correct? Because I certainly know that as a young engineer, I made mistakes. If you haven't yet, then that's great. But you may find at some point that you're the person who realizes that there's an error in their work. We're just simply not perfect. So we can't rely on this idea that we can do our jobs perfectly and then have nothing to worry about. The second common misconception is I can manage the risk by building a strong client relationship. If you are not a consultant, then think about this as relying on managing risk by building relationships of any sort. It could mean relying on your consultants too much. So, this is another thing that engineers might develop, especially if you're acting in a client facing or uh, external facing role or a project manager. Maybe you're involved a lot in developing new business. Is this too much dependence on the relationships as the key? Is starting to believe that your client friend would never not pay a bill or sue you? So, who needs that contract signed right now? Let's just start the work. But unfortunately, friends do sue friends. As trite as that sounds, it happens. And while it is really important for business and for your careers to build good relationships, to win work, to partner well, to minimize the chances of trouble. And I will note, I have seen a dispute come up more than once where it was resolved so much more easily because of the good relationships. It's still, again, not enough to protect against a claim or a lawsuit or non payment of invoices. So it's important to do these things, but consider that when things go wrong, friendships get strained and they often disappear. Your great friend may be swapped out for someone else, or often they're not the ultimate decision maker about serious issues. I don't know about all of you, but I don't have a lot of CEOs as my best pal when I'm working on a project because they're busy with other things. But when a really serious issue comes up, then they may be the ones making the decisions. Or economic conditions could change suddenly and the other side could be desperate. So if you didn't have a contract signed or you didn't have a change order agreed, guess what? Maybe someone's not getting paid, or maybe someone's not getting the work that they expected because it wasn't actually documented. The third common misconception is that quality management and contract tasks, all of this stuff just takes too much time. Understandably, engineers want to do engineering, right? Like that's what we all thought we were here for. And so often, speaking from the consulting side, there's time spent preparing proposals to showcase the great work that people have done and why they should win more work. And then once that work is won, it's like, okay, let's just solve all the problems and get this done. This makes sense, right? But much like I think many of us were surprised to get out into our jobs and find how much of our work involved writing when maybe we didn't want to do that at all. We're like, we like the sciences, we like maths, we didn't want to write. But turns out we have to do a lot of it. A lot of us also don't necessarily want to do what are viewed as administrative tasks. So filing, organizing, filling in metadata, naming folders. These things are really crucial for quality management. And in case of a claim, they're so important for business stability and for being clear on what has happened. And that time that's invested up front prevents so much more time later trying to figure it out, trying to figure out what happened and prove what happened. So, taking the time to execute a contract properly, it means you know what the other side expects and what if you're the consultant, what you're supposed to deliver. Taking time to organize your projects and document important decisions, milestones, tasks. All of this means if a problem comes up later, you'll have clear evidence of what actually happened. And you won't find yourself scrambling to explain, someone told you on the phone to do something, but actually you have no proof, or trying to decipher how the calculations were done and whether they were checked. I've seen so many spreadsheets where someone clearly seemed to know what they were doing, but there might be no formulae embedded, or some years later, there's only initials and you don't know who that was, and you don't have a record of it being checked. So the time put in today is really crucial to prevent those more difficult to quantify impacts later on. And the last one, contracts are so boring, right? On this one, you have a point if you're thinking this. I can't really refute it. Part of the problem is when we talk about contracts, they're written in what we call legalese, right? It's like its own language with its own conventions. It's like learning code, really, is how I've felt about it in becoming more and more engaged with it. But the thing is, if you're a geotechnical engineer, then you are much more common to be pulled into a claim, and the claims in our field are much more costly than other disciplines, except maybe structural. So you have a higher likelihood and potentially larger consequences when it comes to claims or lawsuits. So the topic might be boring, contracts might be boring. That's fair. So I'd still really strongly advise you to get interested in risk management and contracts. Okay, so now I've teed up some misconceptions for you, and we will touch back on how those are relevant. How do we properly manage the risk then to avoid getting caught up in claims or suits, and how do you protect yourself? The first option is to just avoid the risk altogether. So, in the big picture sense, this is often done through a sort of go, no go process. You assess the potential benefits and drawbacks to whatever it is. Maybe it's a client, a project, additional scope, and choose whether to proceed. And if the decision is a go, that's when you want to have identified the key mitigation measures to minimize the risk, having thought about it right from the very beginning. Choosing the no-go option, it means avoiding unnecessary risk, and it means turning down projects, scopes, clients, whatever it might be, that don't offer enough potential benefits to offset their risks. As engineers, we tend to get excited about potential projects and not want to turn down opportunities. If something is technically interesting, we want in. Where our industries can be cyclical, so the work ebbs and flows. Certainly, if you're in consulting, there is a feeling of not wanting to say no or end up with too little work. And then also, I've certainly found that engineers are people who typically want to be of service and help. Like they just legitimately like to solve problems and help people out. And these are really nice qualities. They make engineers great people to be friends with and to work with, but it's also really important for all of us to hone our skills for assessing risk objectively and learning to say no when it's warranted. And if you find yourself unable to say no when you should, you're essentially putting yourself at too much risk. The next big point of risk mitigation or risk management is allocation of risk. This is really crucial if you're making that go decision to proceed with whatever it might be. It's advocating for the proper and equitable allocation of risks through your proposal if you're a consultant and through the contract. And this is important for everybody. Engineers have been steadily heaped on with more assumption of risk over the years. Other parties have wanted to shift the risk down, so it tends to get pushed over to the engineers. And in some cases, it's just not reasonable. It doesn't make sense. I noted previously how we tend to be people who want to help, and guided by that instinct of wanting to help, that fear of saying no, and the misconceptions I mentioned earlier, along with, I would say, this is just me, but I see a general conflict avoiding tendency amongst us. If you're a bit of a conflict avoider, put up your virtual hand, right? Then we often assume risk unfairly because someone else is being sort of pushing it towards us, and we're like, well, we just want to help and we can protect ourselves through these things. So let's just go there. I see one person. Thank you. Right? Conflict avoiders. So I realize it's easier said than done, but the fair allocation of risk means assessing who is truly in a position of control over the risks and what are the potential benefits as well. It's reasonable to assess that. So if your assessment shows you a lot of risk with minimal reward and or taking liability for parties or conditions you can't reasonably control, you're not the party who should take on that risk. There's somebody else involved. And that's not trying to be unreasonable. That's not trying to shirk your responsibilities. It's about being objective and being fair. So allocation of responsibilities and therefore risk needs to be really clear between the parties to prevent it creeping up on you later. And again, I will talk again about roles and responsibilities and clarity in a few minutes. And then the third key point about risk management is mitigation. So we've talked about some ways to mitigate risk already. I've implied some through those misconceptions. But the key ones, and again, not an exhaustive list, there are so many things you can do, but really key ones I want you to take away: quality management requirements. For example, having clear documentation of decision making and of communications from the other side. That's really important. The second one is professional liability insurance. So if you're not familiar with this, it's a special insurance policy that covers engineers for our negligence specifically, because we all know we make mistakes. Therefore, we carry insurance specifically for errors and omissions. So sometimes called E&O, or professional liability insurance, which we call PLI in Canada often. So depending on your employer, this insurance might be a crucial asset to protect in case of a claim. Or I believe a few people registered for sure are with much larger firms who might carry really strong cash reserves and have high deductibles, so they don't want to use their insurance very often. So I'm not going to dive too far into this because the approach varies so much depending on your firm, depending on your employer, and how they manage it. But if your employer uses and relies on its insurance more, it's really important to understand what it does and does not cover, especially as that then relates to contract language. And the last key risk mitigation tool I want you to go away thinking about is a thorough and clear contract. So that is our next topic. I want to give you some basics and a little bit into contract language to look out for today without going too far into detail, given that I know we have a wide range of attendees with different experience levels. So first, why execute a contract? This may not be news to some of you, that it is fundamentally important to form a written contract and for both parties to sign it. That's what we call execution. You have a duly executed contract when the two sides have signed off. The reason this is so important, the key reason, is because it's how you bring both parties into alignment in their expectations and understanding of what is going to happen. And contracts are often viewed as this sort of tedious step. It's like something you just want to get out of the way and get on with the work. But guess what happens when a dispute occurs or when a significant claim happens? Everyone opens the contract to see what it says. And you don't want to be the person opening the contract hoping that it says what you think, but not really knowing. And crucially, if you don't put together a clear, written, executed contract, someone else might decide the terms for you. For example, a judge, if it goes that far. They have to then interpret all of this gray area because it's not black and white in your contract. And you may have heard of a recent case that made the news where someone was held to agreement by a thumbs up in a text thread. So, I mean, certainly that's the far end of the scale. You don't want to be held to contract by emoji, but we want to be like as far as we possibly can on the other end of the scale with our clear agreement that everyone understands. So what's in a typical contract? If you are a bit further along in your career, you might have seen several. You might have a good sense of what this looks like. Some of you may not have seen a typical engineering contract before, and they can take different forms. So they can be from a page or two to hundreds of pages. Sometimes, if we're talking like a consultant, they might make a proposal with some terms and conditions attached. The client signs it and everyone goes on their way. Sometimes a client or owner provides their own contract and doesn't attach the proposal at all. So it varies widely. The key points that should always be considered, again, just the most basic key points: the scope. What are you going to do? So one of the most common sources of disputes and troubles and financial write-offs and things that I've seen in engineering projects is an incomplete or an unclear scope. And one side might have thought they were quite clear, the other side might not. It's really easy for two sides to an agreement to have different interpretations of the same wording. For example, this is a good one. If a scope item says maybe there's bullets and one of them is geotechnical modeling, what does that mean? With what software? How many scenarios are you running? Will the files be provided in native format? Will the client own all of the modeling files? They often want to, right? So if there isn't a thorough, detailed scope that everyone understands, you could have two very different interpretations of what that means. And you can imagine a situation where modeling meant something. Maybe it meant 4 scenarios are being run on certain software, and then you realize more is needed. You try to speak to the client, but the client has interpreted geotechnical modeling to mean, well, everything that's needed to do the modeling. So they don't understand why you think that you need more time and maybe more money to do the work. Next is the schedule. There are so many unknowns in geotechnical engineering. I don't probably have to tell you that, right? So more than most other disciplines, it's so common that unknown things come up, timelines slip, and that's not necessarily our fault. But it's very important to have clarity on expected timelines. And it's also important to assess and kind of think about the what ifs. So, what happens if there are delays, especially if they're not within your control? A good scenario for this that I see happen is if you think of deliverables. So you might see in a proposal a little table and some different deliverables, maybe draft versions and final versions and expected dates for those. So if you're the consultant and you've prepared this, you've made some underlying assumption about how quickly you can go from a draft to a final. Well, what if your client receives the draft and then doesn't answer anything back to you for 6 months? And you're waiting and wanting to finalize it. And what if in the meantime, the professional engineer who would be sealing that final report leaves the firm? Well, then what? Typically, then you need another professional to get up to speed on it, figure it out, and then take responsibility to eventually seal the final report. That's a thing that does happen. And if you haven't made it clear to the client, look, we've assumed you'll take, I don't know, 2 weeks, 4 weeks, whatever you want to say, then the timeline might be affected. They may not understand the potential impact. And then the budget. So of course, this has to be in sufficient detail, consider all the scoping and scheduling what ifs, because those three elements should be tied together and work together. If one is affected, the others are typically affected. And then last, but usually most complex and the thing no one wants to think about, the commercial terms. So these are the small print or the legalese part. And typically, hopefully, will cover everything from what happens if you need a change to invoicing and payment processes to how the contract will be terminated. But like I said, sometimes there's very little detail and not much to them. So let's dive a little bit deeper into the commercial terms. I want to give you a few things to look out for as you're perhaps already gaining experience with this, or maybe it will be a future thing for you. Um, as always, there's a lot more to this, but first thing to look out for in commercial terms to an agreement are minimal details. And this also goes kind of overlapping with the scope part, schedule part, because if you have a case, especially where there's no proposal attached or the scope hasn't been incorporated in the way it was presented, and instead it's reduced to a sentence or some bullet points, is there enough detail for both parties to have clear, consistent expectations? It might be uncomfortable to push back on the language and try to get something more there, but the thing is, clarity is a gift to both sides. So you're helping each other avoid being surprised or feel blindsided or left without something later on by making sure things are thorough and clear. The second thing is unfair risk allocation. So I mentioned about how important risk allocation is as a mitigation tool. You need to look for it in the contract, looking for things like supervise, oversee, direct, take responsibility for, take liability for. Will you, as the engineer, be in a position to be responsible and liable for things you don't really have control over? Or not just that, but maybe aren't the best person to be figuring out, right? So an example is some contracts automatically assign the consultant to be responsible for site health and safety. Sometimes that's not appropriate, right? Like sometimes it is, but often it might be better for the contractor or site owner to take that role because the engineer is maybe not the one who's closest associated, who knows as much about it. They may not have that expertise. And then the third thing is onerous language. So we talked about the types of professional liability and how you're responsible or liable under the law. And we understand what negligence means and how we might have a duty of care and breach it and so on. Onerous language in a contract takes your liability and expands it beyond what would exist at law. This means you're taking on contractual liability over and above what would otherwise be expected of you. And in many cases, this can be problematic, especially if your firm relies on professional liability insurance, because typically that insurance does not cover that additional contractual liability. So if there's onerous language that's expanding your liability, that's on you or your firm, typically your firm, unless you're a sole practitioner, and the insurance is not going to step in and help you out with it. So you really have to watch out for that. To give you a taste of that onerous language that is particularly concerning, there are so many ways this comes up, but I want to give you three key ones to have a little taste of and have a sense of why it could be a problem. The first is indemnity clauses. So these will sound like or read like Party A will indemnify and hold harmless Party B from and against any and all claims arising from blah, 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 blah. So what does that mean? What does indemnity mean or indemnify? It effectively means that Party A will shield and protect Party B from the costs of any claims or damages arising from whatever you've agreed to. You're kind of stepping in front of the other party and making sure they don't have to bear the cost of any of it. And the thing is, these clauses are often quite broadly worded, and so they expand liability substantially, and it can be unfair. There was a case in the US where a consultant signed a contract with a very broad indemnity. It wasn't specific to their own actions. So they weren't indemnifying for their own actions. It was just broad. And in that case, on I believe it was construction site, there was a significant claim. They didn't have anything to do with it, but they were on that project and they'd signed this broad indemnity and they were actually held legally liable to cover costs for something that they didn't do. So this is risky. It's something we need to look out for and make sure the language is appropriate and suitable. The second thing is a high standard of care. So engineers are generally held to the ordinary standard of care. That means what would a typical competent engineer do in similar circumstances? But contracts can elevate the standard by adding certain terms. For example, saying the standard will be first class or the highest standard or leading. The most simplistic way to think about this is, would you want to be compared to the actions of your peers? Or imagine for a second who you think is the foremost expert in geotechnical engineering. Would you want to then be compared to them? Maybe, probably not, right? So we want the standard of care to be at that ordinary, reasonable level. Also, agreeing to something else might void your professional liability insurance. So it's fair and reasonable, and it is the legal standard, that's common for us to have the ordinary standard of care to what would a reasonable engineer do. And then the third is about limit of liability. So the best way to protect against excessive contractual liability is negotiating a limit of your liability that might be as simple as saying the maximum liability under the contract will be, I don't know, the fees or 2 times the fees or something, whatever. It can vary quite a bit. But if there's a really unfair or no limit of liability, you have to really think about the risk there. And there are business reasons to agree to contracts without a limit at times. That's for your firm to decide, but it is something to watch out for and to learn about. So you can learn more about these topics and others Typically through your employer, your insurance provider might have resources, most of them do, or I've put a link there through ACECBC. A little team and I have been co-authoring updates to some papers that go in detail explaining things like indemnities and limits of liability and why they're important specifically for consultants. So you can check out that link and look for the position papers if you'd like to learn more and go into deeper depth that I avoided today. And so we come to our final topic, which is what can you do? I would like you to take away some practical things specifically for young professionals that you could start doing today if you're not doing already. The first is getting serious about quality management, the requirements of your employer. The thing is, those requirements aren't there because somebody likes making rules, even if it might seem that way. They're not there because someone who's bored and wanted to write rules for other people. They're there because hard lessons have been learned in the industry and probably by your firm. And so they're trying to carry forward a better way of doing things. And I especially want to highlight how important it is to have good documentation. So think about someone else having to figure out what you've done. Could they? How could you make it easier? And consider, I will tell you from experience that 5, 10 plus years down the road, you won't remember those tiny details of the kind of work that you've been doing because you'll be busy with other things. The memories will fade, but a claim could still come up that much longer down the road. The second thing is before you begin a task, no matter how simple, ask about the details of the scope, the schedule, the budget. Often the people giving those tasks are very busy and they might forget. So find out what's included, what's excluded, what has been assumed. And then if you're responsible to put together a scope, or as you develop as someone who's doing that, think about those what ifs I mentioned. Think about how to clearly detail what's assumed, what's included, and very importantly, what is excluded. You want someone without your knowledge to understand what you're intending. And again, recall this is a gift to the other side because it's better for everyone if we all understand it from the beginning. And then third, we all need to spend time on our continuing education. You're doing that right now, if for no other reason than it's the law. So devote some more of your time to learning more about risk management and contracts, because these are things you can build upon as your career develops. And if you start now, first off, you'll make yourself more valuable right away by learning more about this. And secondly, you won't find it such a steep learning curve later on. Often, as people start to take more responsibility and go into different roles, it can be quite a bit to suddenly start learning these things, but you could do it now. All right, thank you. That is the end of my prepared content.